Okay, good morning, everybody, and a warm welcome to this workshop this morning, which we're going to run through. So, balancing acts, encryption, privacy. Balancing acts 2.0. Can encryption and safety coexist? And it's great to see the speakers join us as well this morning. Is David Wright. I'm CEO of a UK charity, SWGFL, and director of the UK Safer Internet Centre. And it's just merely falls to me to moderate this particular session. Before I do give the floor to the speakers, just to introduce themselves and add some opening remarks, just to give a little context around this workshop. So. We're building on the success of the IGF 2024's workshop, which was Balancing Acts, Encryption, Privacy and Public Safety. And so this workshop advances that conversation from conflict to collaboration and solutions. Last year we explored how the weaponization of privacy can obstruct safety measures, particularly child protection. And this year we ask whether encryption and safety can truly coexist and how. So we will, as a panel, be exploring some of the technical models enabling lawful access without undermining encryption. Look at global developments in encryption governance, particularly regulatory and standards frameworks. Tensions between platform accountability, user privacy, and state responsibilities to protect vulnerable groups. So we aim to move beyond these polarized positions and explore how multi-stakeholder engagement can help develop rights-respecting, balanced approaches to encryption policy. That's the subject that we aim to cover. So we will be just running through. I'll allow the panelists to introduce themselves shortly and add some general opening remarks before throwing a series of questions that we have to them. Then there'll be an open floor. We'll be enabling you to ask particular questions of the panelists based on what it is that they've clearly contributed. Obviously, the code of conduct applies to all of us. We have seen some very emotional or emotive subject that this instigates, but please, I ask that code of conduct that the IGF upholds is indeed upheld. So I'm just going to start off by allowing, the panelists to introduce themselves. I'm going to start off with Andrew.
Hi, good morning, everyone. My name is Andrew Campling. Congratulations for surviving to the final day of our event. I work in the sort of tech space, amongst other things, spend my time at some of the STOs such as the ITF, and also I'm a trustee of the Internet Watch Foundation, which is focused on finding and removing child sex abuse material online.
Andrew, thank you. I'm next going to throw it to Katie, who's joining us online. Katie, if you can introduce yourself and as well some opening remarks.
Yeah, absolutely. Good morning, everyone. I'm very sorry to not be there with you in person. I'm Katie Noizo. I'm from the FBI, and I have been working in next generation technologies and lawful access for the better part of 5 years. And really what that focus is on assessing emerging technologies, emerging and disruptive technologies, and really preparing our environment. I have some really fun portfolios. One of those, of course, is lawful access, and we're going to talk about that today. But I also have the FBI's patent program, which is super fun. We have 26 patents, which most people don't know about our organization. But I also have the group that is involved in our technology standards. So we have membership and even leadership roles in many of the international standards development organizations so that we can be shoulder to shoulder with all of our multi-stakeholder partners from a public safety point of view. So it's a great collaborative space. So very happy to be here, at least virtually. Thanks.
Thank you, Katie. Next, if I can ask Honey to introduce and also opening remarks. Honey.
Yes, good morning. I'm Hani Makola. I currently work for the ICT regulator in South Africa, ICASA, and I am also vice chair of the Study Group 17, responsible for security of the International Telecommunications Union. So I am fairly new to technical work in that respect, but I am very passionate about regulation, of course, as I work for the regulator. But it's important to also highlight that regulation need not hamper innovation, but at the same time, so in this discussion, mainly we want to look at that balance of regulation for protection of privacy, but at the same time ensuring that there is access, especially for the protection of children online participation.
Thank you, Honey. And finally, if I can just throw it to Lloyd to an introduction and opening remarks. Lloyd.
Good morning. Thank you for the introduction. So my name is Lloyd Richardson. I'm the Director of Technology at the Canadian Centre for Child Protection here in Winnipeg, Manitoba, Canada. I've been doing this work for about 20 years now. Our organization operates Canada's national tip line for reporting online crimes against children. We also operate a global tool called Project Arachnid, which deals with the removal of child sexual abuse material globally. We see the front lines of harms to children. I've been working in this space a long time. Previously, I worked in the technology sector before intersecting with children in this space, and I'm very passionate about this issue. Pleasure to be here today.
Thank you, Lloyd. And it would be remiss if I didn't remark really on the time of the day that both you and also Katie join us. So being 4:30 in the morning, so I appreciate the commitment that you've shown. It's going to be a long day for you. Thank you very much. So I'm actually going to start off with throwing the question to Katie, or actually indeed a couple of questions to Katie. So, Katie, just to give you these questions. So, what are the real-world consequences of encryption on criminal investigations, particularly those involving children, and also how can law enforcement seek access in a manner that aligns with human rights and avoid systematic vulnerabilities? Thank you, Katie.
Yeah, thanks. These are great questions. First, let me remark, Honey, I really loved what you just said, which is regulation need not hamper innovation. And that's probably a great place to start, which is I couldn't agree more. And it's been only the collaboration, honestly, with industries that are involved, even in this space where encryption is now, becoming a challenge, that we've been able to, gain, I'll even call it superiority. I mean, it's only against adversaries and criminals, and been able to bring them to justice, been able to conclude successful investigations because of the technology partnerships and being able to stay ahead, or at least have, some parity with understanding the criminal tactics, techniques, and procedures, and, the methods they're using to turn our citizens into victims of crime. And again, take that very seriously. I think just, again, a quick general statement is that encryption and safety have to coexist. We're here today because they have to coexist. We have to find a way. The challenge is real. And let me kind of explain why. I think sometimes this gets missed in a little bit of understanding. So for those of you who, may be new to this conversation, first, welcome, and we very much welcome your perspective. So we're a very open group here, both the panelists who I've known for some time, but really all of us in this space. There are two parts to the process. The first is where we in law enforcement, we actually need to have predication, and we need to be able to show and, offer that predication to get an order. And so that's the first step in a rule of law country like the United States. It's the first step is we have to prove to a judge that we have predication to be able to request the information in question or request access to digital evidence. It's the second part of the process where the focus of this conversation and others ends up going. Once we have that order, then what happens? And in the case of encryption, it's really kind of an interesting one, and particularly end-to-end encryption, which is in many cases, when an application or a technology was rolled out, it wasn't end-to-end encrypted. So for sometimes, up to 7 or 8 years, law enforcement had this process with providers where we would retain, we would garner the order through the process, we would present the order, and then we would have the technical access needed. So that two-part process had parity. Now, in the case of deployments, and I think this is the challenge for us, is now we in law enforcement, we know what we're missing. And I can give you some examples. First, let me just state, we're always asked to quantify the scope and the scale of the impacts. We do try to now have a little bit of an understanding of the quantifiable side of this. So we're trying to, and we ask questions of our investigators across all of our field offices on a quarterly basis. Are they facing these impacts and challenges in the cases? And I was able to share that figure, and I'm able to again hear that we're over 17,000 cases impacted. And that's of all manner. It's in all 56 field offices are reporting these impacts. And it's everything, when I say impacts, it's everything from, needing to approach a challenge or approach an investigation using alternate methods, which may or may not be as successful as giving the order to the provider and requesting that technical assistance or access to the evidence that way, all the way to really stymieing or stalling a case because we just don't have the evidence to continue a successful investigation. And one of the biggest impacts that we see year after year is violent crime against children and child sexual abuse material. Let me bring that home to a case. Again, what I told you is in many cases where we are able to see and have access to the evidence, we now know what the cost is when it is then in what we call warrant proof, meaning it is behind the end-to-end encryption with no way to access the content. Here's how critical that is. Many of you have either experienced this in your own countries or you've heard about our cases on sexual extortion or what we call sextortion. We had a very, very prominent case of a young man named Jordan DeMay in Michigan out of our Detroit field office. That individual unfortunately took his own life because he was being extorted by criminals who were perpetrating their crime from Nigeria. Now, we were lucky in this case that the application in question and the communications were available to us. They were not encrypted. And so we were able to see how they groomed Jordan, how they approached him, how they got him to share information. And then ultimately, and this is so key because it went to sentencing, one of these individuals actually goaded Jordan to take his own life and was telling him, you should take your own life. That featured prominently in that individual's sentencing. So it is crucial for seeking justice for these victims, for the parents of Jordan DeMay in particular in this case. But it was crucial for us to understand that there were also over 100 other victims that this crime was being perpetrated against. And that's maybe one of the key challenges on what we're missing now is that we can't stop the harm when we can't actually follow to conclusion a successful investigation in this space. I'll very quickly touch, because I think I'm probably way over some time that I'm allotted here, but I'm very excited for the conversation of what is in the realm of the technically possible. How can we actually find a method, a technical solution where encryption and safety can coexist? We've been very encouraged by some of the research and white papers and throwing things out like homomorphic encryption, looking even at prospective solutions where it's a little bit like a wiretap, if you're familiar, which is from this point forward with the order, now we'd only be affecting the architecture of the single subject for who we have predication. So I think there's a lot to discuss in this space where we could find comfort, we could find observability, an ability to audit, ability to really look at what we're doing in law enforcement and be able to view those processes, but also ensuring that we're enabling the access that we want to make sure that we can stop the harms, conclude successful investigations. I'll stop there, knowing that hopefully we're going to have a little bit more of this conversation later. Thank you so much again for the opportunity.
Thank you, Katie. Yes, we shall now move it on to. I'm going to throw the question next to Andrew on my left. Andrew, in actual fact, there's two, perhaps three questions here. So I'd ask you, how do privacy arguments become weaponized in standards development forums? Which is the first question. What are the barriers to greater diversity and child protection representation in standards setting bodies? And then perhaps finally, as just a supplementary question, are there any examples that you could share that might demonstrate good practice to us? Andrew.
Yeah, thank you for the questions, David. So firstly, in terms of how do privacy arguments become weaponized? And I'll broaden it to say not just in standards development organisations, but sometimes in other fora. As David said in his sort of opening remarks, it is an emotive topic. Whether we're talking about privacy or child safety, both of those are emotive topics. So sometimes that in itself makes a useful discussion challenging. Sometimes, though, we do have examples where the phrase privacy is used to close down a meaningful conversation and just use as the reason to not do something. And it may be a good reason, I hasten to add, but I think it needs better explanation than just we can't do that because privacy. I think you need to unpack that and say specifically why, and then if it's in an SDO, for example, dig into the specific technical reasons and understand whether they are indeed valid or whether there are solutions. So there may be a technical solution, and there often is, that will give you both privacy and child safety. In reality, they don't need to be in opposition. And in fact, in some cases, actually, if we talk specifically about encryption, inadvertently, the use of encryption to improve privacy can sometimes both weaken privacy and security. And there are some current examples where metadata is being encrypted to improve privacy, but some of that metadata includes, from a technical point of view, what are called important indicators of compromise. That gives signals to your firewall or your enterprise security software that a system has been compromised by malware. And by encrypting that metadata, you may actually be open to attack. So ironically, you may be losing your privacy because of that encryption. So I think we have to be careful sometimes that we don't blindly do things for good reasons without fully understanding the consequences of those reasons. I'll give you a different example. We know from research that the big so-called end-to-end encrypted messaging platforms are widely used by offenders to share child sex abuse material. There's extensive research with an enormous sample size. Last time I checked, it was over 60,000 paedophiles were in the sample, explaining what tools they use, and these are the tools they use to share their material. And again, often the conversation on, well, can we do anything about that, is closed down straight away because we can't do anything with end-to-end encryption because of privacy. Whereas, in fact, there are techniques you can use to block the sharing of at least known material without the need to weaken encryption, without the need to create backdoors. There's something called client-side scanning can be used, which doesn't affect, as I say, the strength of the encryption. There's absolutely no need for a backdoor, and ironically, many of the messaging platforms already use that technique for user convenience features. So it's already being employed in the software. So people that object to it in principle possibly don't realise that it's already in the software that many of us use. So you can do that without, as I say, affecting encryption or privacy in any way. The only time you impact privacy if it turns out that someone is trying to share known illegal images. But then, to be frank, and this audience will understand this, you'll understand that privacy is a qualified right. If you are doing an illegal act, then I think it's reasonable that you might at that point surrender your right to privacy. Your second question, David, what are the barriers to greater diversity and the representation of child protection groups in standards bodies? In fairness, I think, to be more specific, it rather depends on the standards body. So, for example, there's a number of us here this week from the Internet Engineering Task Force, or that participate in that. There are no barriers. Anyone can attend. You don't have to pay to attend remotely. You obviously have to pay to attend in person. And by the way, the remote tools for attendance at the ITF are fantastic. So you attend on an equal basis to the in-person participants with access to the mic cues, the conversations, and so on. That said, and some of the other SDOs, there are other barriers, like you have to be part of a national sort of group or pay to participate and so on. So it depends on the SDO. There's whether there are specific intentional barriers. There are other barriers, though. So the cost, there is a real cost to attend. The ITF, for example, we to try and diversify attendance, we meet in different parts of the world, rotate each time. So there are pretty extensive travel costs, hotel costs, and so on. There's also the cost of people's time. Not only do you have to commit to attend the meeting, so if you attend in person, you're committing to attend for a week. With any of the STOs, you typically have to attend for a while to understand how the system works and to engage with it effectively. So you're usually looking at a multi-year commitment to effectively engage, and you obviously need to bring relevant knowledge. So just wandering in off the street, as it were, would be quite challenging, I think, probably in any of the SDOs. Having said that, it's absolutely an important thing to do, because any of the SDOs can always benefit from better diversity in their attendance. So again, I'll refer to the ITF as my reference point. We have fantastic representation from the tech community. In my view, we are appalling on gender diversity and need to do significantly better there. And we absolutely would benefit from better representation from groups with experience outside of the tech sector, whether that's network operators, or whether that's civil society groups, regulators, governments. And if we had that broader representation, we would have better standards. And I believe that's true of all of the SDOs. So please, if you've got the right sort of knowledge level to be able to engage, please do so. It'd be very worthwhile. And then final answer, why would it be worthwhile? Well, as an example, parental controls are probably the one tool that parents have to try and manage, if that's the right word, the user experience that their children have. But we know that there's so many of them, and even technical experts struggle with the parental controls because of the sheer number of them on any given device. You've got the sort of the operating system level controls, the application controls, maybe your ISP's controls. They're all different. They don't interwork. They use sometimes the same terminology to mean different things. And I have had a CTO of a technical organization tell me that he struggles with the parental controls, and he certainly has, enormous technical competence. So it's a problem. Where we can use SDOs, some of us are working on a proposal to develop a protocol so those parental controls can interwork, so they can exchange signals with each other, so that you don't have to invest time in every single one of them to put reasonable controls on your device. And if anyone's interested in that, let's have a conversation afterwards. But that might be a useful thing that we can do, where the civil society can actually input useful knowledge that isn't currently present in some of the SDOs.
Andrew, thank you very much. We're next going to turn to Honey, and so Honey, your two questions. So how should encryption policy address regional diversity, particularly in the global south, where technical solutions may be harder to implement? And what are the regulatory models that show promise in balancing safety and privacy? Honey.
Well, thank you so much for the question. And I just want to pick up a little bit on what Katie said. And I completely agree that encryption and safety are not mutually exclusive. And Katie's feedback also highlights the importance of international collaboration, with the example that she mentioned from Nigeria. But to make encryption policies work together, we need to think about how diverse our starting points really are, especially in the global south. As you said, we have the example of South Africa, where I come from, where cryptography providers have to register with the state. And then you also have Mozambique, where encrypted documents must be decrypted by experts. So those examples show that countries are really trying to balance the safety, privacy and capacity, but just in the way that fits their own local context, that whether this is wrong or this is right. But the main point is that they are trying to have a certain balance. And then in the global south, we must also take into consideration that we have limited local infrastructure, including data centers. And this also poses a challenge, forcing some of the countries to rely on external resources for data storage and processing. So when we talk about global encryption policy, for me, it boils down to three things. Flexible policy frameworks that support diverse paths of implementation, and at the same time also respecting the sovereignties of the specific countries. There's a need for investment in local capacity, especially for regulators, law enforcement, and the technical community as well. Boris mentioned the technical work involved, and I believe that meaningful participation of the global south in technical standard setting is very important. So we're not just adapting to the decisions, but we are helping shape them. That provides a real opportunity while we're trying to build capacity and technical skills and capabilities at the same time. But in the end, the encryption policy will work if it doesn't reflect, it will not work if it doesn't reflect the diversity of the different regions. And in terms of the second question, what regulatory models show promising balance, safety and privacy, I'm assuming that is still with regard to the global south. So I think the most promising regulatory models are the ones that enable law enforcement access without weakening encryption or undermining the user trust. Frameworks in my country, South Africa, Nigeria, and Brazil require that access to encrypted data be granted only through judicial authorization and based also on clear legal criteria such as necessity and proportionality. So this ensures a balance between law enforcement capability and the protection of fundamental rights. While South Africa's legal framework incorporates judicial oversight and provider registration, there is still definitely room for improvement. We need greater clarity in terms of the obligation on cryptography providers, alignment with evolving international norms also. But I do believe that we are on the right path, but there is still room for improvement.
Bonnie, thank you very much. And just by way of a final contribution, going to throw it to Lloyd. And so, Lloyd, from your perspective, if I can ask, how does strong encryption affect the fight against online child sexual abuse? And secondly, as well, what safeguards are needed to ensure child protection is prioritised in encryption debates? Lloyd.
Yeah, thank you. Firstly, I would agree with all of the previous colleagues. It aligns with everything that I was going to say. I like to encapsulate it by saying it's not necessarily about banning encryption, banning this cipher, et cetera, et cetera. It's more about the responsible use of encryption. So I think there was a statement before about the weaponization of encryption. And I think we can point to real examples of that in the world where we see, for example, Meta used to have just client-server encryption in place related to Facebook Messenger. There was an enormous amount of child sexual abuse material being traded in that way. They were able to prevent it from being distributed and disseminated. They chose to turn the lights off with that. That is an example of irresponsible use of encryption where you're seeing a lot of harm being created and you're essentially turning a blind eye to it. So in a lot of ways, when we're talking about media distribution in adult sort of contexts, I think there needs to be methods by which we can identify child sexual abuse material specifically in a media sense. But there's also areas where we see children being affected in terms of adults communicating directly with children. So that touches on some of the examples Katie gave earlier about where adults have access to children on the internet by way of a platform not delineating children users or turning a blind eye to what is obviously a child user and an adult user. They intersect with terrible consequences. I can echo what Katie said about we've seen a handful of suicides here in Canada for the exact same reasons. Our tip line deals with dozens of sextortion requests every single day. And the idea that we would turn down so that's sort of the perverse weaponization. If I'm industry in this space, that's a cost center for me. If I can turn on end-to-end encryption and avoid any sense of moderation, it's cheaper for me. It makes more sense to approach the situation that way. So I really see problems with that, where we need to look at where encryption can be applied in a responsible way. I would use examples that we see in the brick and mortar world in terms of what we see with the financial institutions. So certainly if banks decided they wanted to have financial transactions completely end-to-end encrypted from point to point, that would be a great scenario for people to perform money laundering. The reason that they're not allowed to do that is because we have regulation in place saying, no, you may not. You can use client server in this space and you must inspect these communications here. That's what we've developed. We've learned lessons over time that if you don't do that, you're going to have problems with money laundering. And it's the exact same thing that we see on the internet, yet we've been incredibly slow to regulate in this space and apply the appropriate technologies where there's a balance of safety and privacy.
Lloyd, thank you very much. Now, what we're going to do, clearly we're going to open the floor for particular questions. Before I do, I'm just going to turn to my colleague Boris, who's compiling or is watching the online comments. So, Boris, if I can invite you to the microphone, if there's any particular questions that we've seen online that can be addressed to the four panelists.
Thank you very much. Hello, everybody, dear moderator and panelists. There has been a lovely discussion in the comments, and thank you everybody for your contributions. I'm going to try to convey this the best I can, so please help me. First one was, is it possible to create an encryption protocol that balances personal privacy and national security without compromise? The second part as well was a question, did not know about the FBI standards work. Is FBI, which organization is it working with? There has been a couple of comments on IGF, so I'm not sure whether these are correct or not. Please correct me. but IGF waives fees for NGO participants, one contributor said, and decisions are made remotely and physical participation is not required. Thank you so much for that, if that is correct. There was one question in regards to parental controls, which I think might be interesting. Perhaps maybe governments, and kind of suggestion from a contributor, could fund better development of parent and child-friendly protective tools for free deployment on widely used systems. I think it was an interesting perspective. As well, there were kind of questions and comments depending on the contributions and Andrew's contributions of kind of examples of privacy concerns that get weaponized. If there's any, is there any that you could share, dear moderator? I hope that is enough. And if you would care to ask the panel. Thank you so much.
Okay, Boris, thank you very much. We'll have a go at answering some of those questions before we just open the mic. So I think there was an easy one as well. Katie, if there was any information around the organisations that you work with that you referred to?
Yeah, thanks. I'm glad to hear the interest in that. So yes, so I'll just give a couple of examples. The first is in the International Telecommunications Union. Honey, I love seeing you as Study Group 17. We're involved in the study groups there from all manner. In fact, we're just getting into the artificial intelligence study groups there and trying to keep pace from a public safety point of view. So we're in ITU. In ICANN, Internet Corporation for Assigned Names and Numbers, that manages the domain name system. If you're not following that group, we actually have the co-chair of the Public Safety Working Group is from our organization. And that's really heavily focused on really stemming and making sure we all collectively understand DNS or domain name system abuse. And then also accesses to IP addresses to be able to make victim notifications. How's that process working? You know, again, is there a observable law enforcement access system being applied to access some of that information? And how are we doing that in the collective? So those are two kind of prime examples of where we're very involved in the standards organizations.
Thank you, Katie. So the other questions, I think, Andrew, I'm going to turn to you here. They're particularly the ones to do with the encryption protocol and also parental controls points as well. So if you can take both of those.
Yeah. And I'll maybe briefly touch on one of the others. So on the encryption question, there have been proposals put forward where you can have encryption, but still have, I think, to respond specifically to the question, governmental access to the encrypted content. I think it'd be perhaps understating to say that I think there's some skepticism as to the appropriateness of that approach. Not my area of expertise, but I think it was one of the proposals was called the Ghost Protocol, but it has been criticised as effectively providing a backdoor that could be exploited by sort of bad actors. So there are issues with that, but they're happy to provide more information of that online. I think on the fees for the ITF, I wanted to mention on that, you can participate online with literally no cost, no financial cost at all. There are no question fee waivers for remote access, unlimited without question fee waivers. There are a small number of fee waivers for in-person attendance, but you need a very clear justification because ordinarily you've also got airfare costs and hotel costs to pay, and there's no funding for that. So you'd need to clarify why you needed a fee waiver for the registration fee if you can afford to be present anyway. But for remote access, totally free. Somebody also asked if I had any examples of weaponized discussions. I do, but I don't think it'll be appropriate to share those because we want to keep this as a constructive discussion. Did I miss one? I maybe. Sorry, parental controls and government contribution. I think that would be a good conversation to have. Equally, it might be a good conversation to have sort of governments reviewing the operation of parental controls and maybe at least getting involved in the discussion about the usefulness of having a protocol so there could be some interconnectivity between those controls. Some standardization there, I think, would be hugely welcome.
Okay, thank you very much. Okay, if I can now if I can just ask you to introduce yourself as well, and if I could ask you to keep it to a couple of minutes, that would be good. Thank you.
Sure. Hi, I'm Warren Kamari. I spend most of my time in the IETF, and I'd just like to thank Andrew for noting how open it is. I also want to amplify his message that we need greater gender diversity, but also participation from regulators, civil society, etc. As people have noted, it is free to participate remotely, and our next meeting is July 19th to the 25th. If you'd like to participate, come chat with me. I'm happy to help you figure out how to get started.
It's in Madrid, by the way, if anyone in Europe wants to attend in person.
Thank you, Warren.
Hello, so my name is Simon. I'm a student here in Norway, and I wanted to ask the panel their perspective on this, as my view is that if we start doing these things as allowing governments to access encrypted communications, and yeah, you can say we do client scanning and only on an alert of child sex or sexual abuse or anything related to that, I don't see how this won't harm things as journalism, as if a government turns corrupt, how can journalism keep communicating and stay safe for communicating and criticizing the government?
Simon, thank you very much. Okay, I think we'll take each question in turn. So, Andrew, do you want to? Yep.
I offer maybe a thought on that, and hopefully some of the other panelists will as well. So thank you, Simon, for the question. Specifically on client-side scanning for the sharing of known child sex abuse material, there are a number of ways that you can insert controls. So, for example, you can only accept the hashes to get to the specifics from a trusted flagger. You can cryptographically secure the hash file that's being shared to protect it from being interfered with by a badly intentioned third party, including a government. Ultimately, though, I think we have to be honest that if there is a government with bad intentions, there's perhaps other tools that they have, other levers they can use anyway, and there's maybe not technical solutions to that. There are other solutions needed, but I think you can put some safeguards in to protect against that abuse. And again, happy to have a longer discussion offline in the interest of getting more people. Great question.
Can I extend if there's any response to that, Katie, Honey, or Lloyd?
I'd weigh in by saying there's a little bit of like confusion of throwing in the government automatically there. There seems to be like the automatic distrust, but in the examples we're talking about, it's more the man in the middle being the person in industry who's doing the intervention there in terms of data, which doesn't automatically mean the government is decrypting and looking at anything. It's incumbent upon the company to share that information with the government, likely based on a judicial order, depending on what country you're in. So like it's a sort of a hypothetical based on a particular government in a particular country. So it's hard to answer it really specifically. But what I could say in the context here, I don't see that. I don't see the government as the interceptor of anything there. It's industry who's doing it.
You even got a round of applause there, Lloyd, as well.
I was going to weigh in real quickly on that one too. Is I think these are good points, and that's I think part of our reason why we're asking for this technical assistance. As I said, there's like a two-part process. One is for us getting the order, and then serving that process right to a provider. But I think that's why it's so important to have the provider in the mix of these, processes, because there then is a check and balance. I think one of the challenges for journalists worldwide is that, like I think Andrew was saying, there are all manner of tools used against them. And by the way, that's part of our protective mission, is to ensure that we're protecting, right? One of the things about privacy that I think is interesting is when you define privacy, if you look at a lot of the terms of service for a lot of the providers who are providing these services, it it wants you to be free from harassment. So that free from harassment in your example where you're saying there's harassment coming from potentially an authoritarian regime or any other manner of exploitation there, it's how do we protect against that? And that is one of the reasons why for us in the FBI, we're so keen to, I think, have the partnership and collaboration with the process of the orders that are provided to a provider, and there's another party that can offer some checks and balances and make sure that they're only delivering what is actually covered in the order. When we start getting to other techniques like computer network exploitation or hacking tools or things that are used against journalists regularly, that's where I think you get into this ungoverned space, where those accesses are you no longer have any of those checks and balances. So it is a really good question to ask, a really good point to make that, there are structured processes versus unstructured processes, and why we favor finding the solutions here in a collaborative manner with the providers to ensure that there is the ability for auditing and for some controls around this.
Thank you, Katie. Okay, if I can turn to the next question, please. Thank you.
Thank you. I'm Tapani Tarvainen, here representing Electronic Frontier Finland, but my background is at the university. I'm a mathematician in computer science, so I think I understand these techniques a bit. First, a quick comment on client-side scanning. I have studied the idea a fair amount, and I really don't think it can be done safely. There are lots of problems. I'll just mention one that hasn't been come up. It basically means installing a software on everybody's phone, and that would be an irresistible honeypot for all kinds of bad actors, notably including intelligence agencies in countries we really don't want to have listening to our talks. But I was intrigued by the mention of homomorphic encryption. I think I understand how that works. I know what homomorphism is, and I don't see how it could be effectively used here. All the proposals I have seen seem to be based on either misunderstanding that simply don't work, or else in effect amount to breaking or circumventing encryption. And whether you are like in client-side scanning, you are actually not technically breaking encryption, you are circumventing it, but the effect is the same. So in particular, I'd like to ask if you have a concrete implementation or even theoretical paper that opens up how homomorphic encryption could be used here, that actually has a testable code, or even theoretical paper, because it's too heavy to be run on a phone at the moment, and the solutions I see effectively amount to sharing the key, breaking the encryption. And to save time, it's the same question about differential privacy, but I won't go more deep on that. Thank you.
Thank you. So just before I open it to the panelists, so we do have apologies from one of the panelists who was actually going to be talking about some of the technical solutions. So Arnold is not able to join us today. So I suspect, although I am clearly going to open it to panelists, that the question about homomorphic encryption was one that Arnold would have probably have taken. But equally, I do open that floor. Andrew, you?
Yeah, I'll pick up the question on client-side scanning. And perhaps it's a great question, because I think perhaps we need to have clarity on specifically what we mean and how it could be done. So what I'm talking about is, let's say WhatsApp. I'll pick on that purely as an example. The actual code in WhatsApp does the client-side scanning. So not a, let's say, government-supplied piece of software. That would be, as the questioner said quite rightly, problematic to have a third-party software. So it would be the application provider that installed the functionality. And by the way, if you think that's just a problem in principle, as I mentioned in my opening remarks, it's already in your phone. An example of that, and again, I use WhatsApp, but it applies to other messaging apps. If you type in a URL in WhatsApp, unless you've disabled the functionality, it will by default sort of produce an image of the landing page within the message when it's sent. That's client-side scanning. It's looked at your message, the actual content of the message, worked out that there's a URL there, it's actually fetched that from the relevant site. I believe with WhatsApp, it's actually in doing that. By the way, it shared your IP address. So if you're concerned about privacy, you might want to think about that. Whereas if you do client-side scanning of images, so to be clear, what I envisage is not scanning your message at all, only scanning any images, any files that you may wish to include with it. All you're doing on the client is turning the image into a number. So you don't need to know what the image is. You turn it into a number. All you're, if you like, sharing, if you like, is comparing that number to a list of known CSAM material. So my view, and again we can debate this afterwards, is there are no privacy implications with that unless there's a match, at which point, if you are sharing no CSAM, known CSAM, I think you've surrendered your right to privacy at that point anyway. But yeah, we can continue that discussion. But I think in that specific implementation, there isn't a concern with a third-party piece of software. I don't know if anyone else wants to comment on that or on the homomorphic encryption point.
I was going to exactly open it to so Lloyd, Katie, Honey, if there's any response to those questions.
Yeah, I definitely want to weigh in. I've been watching the chat, by the way, and thank you for putting your comments in there and your feedback, as we're having this discussion. And I really want to take up sort of like, how do we find some compromise here? I know that the people on the panel and the people in the chat and the people who are in the audience do not want children to be exploited. They don't want child sexual abuse material, and all of us want to ensure there's safety there. So let me open just sort of, and please, you can throw it in the chat, and I hope I'm not breaking any protocol here with the panel, but I'm just interested. Like, we've been really trying to figure out what's a workable way forward here. We've been interested in reading papers about abuse-resistant law enforcement access systems, for instance, and things that are, trying to build trust, which has to be a key here. And we're, I understand the criticisms of the FBI. We all understand them, and we want to earn the trust. And so we can only really, I think, do that if there are these processes, right, where there are orders involved, there's some manner of, auditing, there's some manner of transparency around these processes. So I wanted to put forward this idea of that we had heard before, which is looking at this prospective solution. Yes, I'm the first to say it's not going to resolve all of the challenges we have with access to digital evidence that we have authorities for. However, maybe it's a starting point for these conversations, which is if we're looking at a prospective solution, what I mean by that is it's kind of like we give the order to a provider who is managing the encryption already. That's what these companies do. And they're doing all manners and sorts of things around that encryption, like patches and other things. And I know some of that is different. But if we looked at a prospective solution where we were then only affecting the architecture of a single user with predication, is this something that could be perceived as workable by folks on all sides of this debate and conversation? Is this a starting point for a true technical solution that provides, kind of the assurances that folks are looking for, can build some trust, but then also at least restore some of the access that we already had? And I do think that gets missed in this discussion, is that for many, many years, some of these platforms did not have a full end-to-end encryption solution. That gets added later. So that access has been impacted without a solution in mind, even though there's, again, global recognition about the authorities. So I'm just hopeful that this conversation can come out of the back and forth on this is why we should have no, and this is why we should have all, and where can we meet in the middle? And I've really enjoyed listening to the other panelists here talk about, some of these proposals. So I'm very interested in hearing, more discussion around that. Let's maybe stop with, and I think Andrew threw it out, the no's and the weaponizing of that it can never happen, and find that space in the middle where some of this can and should happen. And I'd love to take up fully the discussion of homomorphic encryption. I agree there are challenges at scale. It's also, I think the use case there is more for narrowing based on characterization than it is for really decryption. So I'm with you on that, but I think there's some promise around if you established a homomorphic model up front, some of the opportunities. But again, would very much like to engage in some discussions with more technical folks. Over.
Thank you, Katie. Lloyd or Honey, any remarks?
I was going to touch on the example that Apple pretty much fully built with neural hash. It was a couple of years back, and then quite quickly threw in the garbage. It was audited by external folks. It was a complete example of how you can do client-side scanning. I'm not saying that I particularly favor such a solution, but it is a potential solution to addressing child sexual abuse material in the environment. And it actually, I would argue that it actually sided on privacy more than child protection. But again, better than nothing, which is where it is now.
Thank you, Lloyd. Perhaps that is a starter for the conversation that Katie's called for too. Okay. Sorry, Honey, if you would like to.
Yes.
Yeah, please.
Yes, not necessarily on the specific comment. There's some comments on the chat that I would like to maybe respond to a little bit, if I'm allowed.
We just a minute, Honey, because we can't actually see the comments. Boris, are there? I guess it's difficult to know what the comments are that Honey, can you actually introduce what the comment is that you would like to specifically respond to, given that we can't see those comments?
Yes. So maybe just weighing in first on the one that was asked by one of the audience on the government involvement, which we all heard. I think it also boils down to what we discussed last year in this very panel on the issue of geopolitics when it comes to international law and how it can pose a challenge. So that question basically speaks to the different governance structures that are there, and we really need to find a way of working around it. But for me, I think it boils down to the importance of why judicial authorization is important when granting government access, and also the clear legal thresholds that needs to be defined in legislation or policy, and the transparency mechanisms also need to be embedded in such policies. That's the first one. And then there was a comment by Ian saying that the Electronic Communication Transaction Act by South Africa has drawn a lot of criticism. And yes, I do agree that he is right. It has drawn criticism, particularly regarding clarity and alignment with global practices. But that said, I'd just like to mention that I believe South Africa is on the right path. And as I mentioned, judicial oversight and provider registration are already embedded in the framework, which is an important step in balancing rights and security, which the workshop really is about. Yes, there is definitely room for improvement, clear obligations for providers, like I said, stronger procedural safeguards, and better alignment with evolving international norms. And that's the beauty of policy in this space. It is constantly evolving, and regulators also need to be aware of that. Yes, those are the questions that I wanted to respond to. Thank you.
Thank you, Honey. We may well just come to Boris, you just as after this next question, so I'll just line you up for that one. Please, thank you for waiting so patiently as well.
No problem. My name is Vinicius Fortuna, and I work on Internet access, resilience, and privacy at Jigsaw. And thanks for this important conversation. I think, unfortunately, it was a little bit one-sided, so I wanted to add another perspective. So like Katie mentioned predication, but like with the big South Typhoon hack of the US telecoms, they leveraged the wiretapping infrastructure that is being promoted here, and that put citizens at risk, including governments and children. And predication didn't help us there, didn't protect us. Andrew mentioned the weakening of security due to hidden indicators of compromise. So I want to point out that like you can only use indicators of compromise after you've been compromised already, and maybe you were compromised because you're not using encryption. But it can help in some cases. But like I'll mention end-to-end encryption. I want to actually be constructive, offer some ideas, and first is that like we need to understand that end-to-end encryption is protecting the channel. You can still see the data on the endpoints, and it's being brought up here. So I can run like malware protection or parental controls. I actually use encrypted DNS with malware protection, and parental controls. I think is a good solution, but it needs to be improved. So I think that is work that needs to be done. I think that's a good suggestion. And on investigation, like the victim has the access to the data, right? So you can work with the victim to try to get the criminal because they can give you the data. So that's another idea. And then there are some new encryption standards that are helpful. For example, there is Privacy Pass, which was actually developed at the IGF, that allows you to make attestation and prove that you can have some property in a privacy-preserving way. So you can do age verification in a privacy-preserving way, which I think will be really helpful. And last thing is that even when we use HTTPS, the domain names are still in plain text. With AI, you can actually tap into like your child's school Wi-Fi and collect the domain names and create like a profile of your child, and then use that for targeting and extortion, which is scary. And so we need to adopt standards like encrypted DNS and encrypted client hello that will hide that information and make them safe.
Vinicius, thank you very much for those questions. And I'm just going to open that. Andrew is...
Could maybe go to Katie first, because I think she might have something to say about South Typhoon, maybe. I think she's better informed on that than any of the rest of us, if she wishes to comment.
Yeah, I mean, I think there's a lot of discussion around that. You know, the lawful intercept, it wasn't actually the vector for attack, but the information was accessed. So it is absolutely something we're concerned about. And another panelist or another person in the chat, sorry for us to keep going back to the chat, but there's some great discussion going on there. There was a question asked to me of, you know, is the FBI concerns around, you know, encryption and what we're asking for. And absolutely, that's why we are, you know, I'm standing here before you today saying we are not against encryption. We're not against end-to-end encryption, but we also recognize there is a balance here. And that's the one of the things where, you know, we're really trying to have this conversation with all of you and with each other, because we haven't had these conversations before, which is what are those solutions for balance? Again, I know all of us are committed to doing better about stemming child sexual abuse material. So what are those solutions? What are the ways that, you know, and again, I understand you're absolutely right, making sure that victims are able to have an easy way to report and preserve the evidence to be able to report it. But the challenge for us is that, you know, the victims are sometimes not even in the mix as far as, you know, and with extortion, of course, you know, there's a lot of challenges, or let's just say, because, you know, if someone takes their own life, or again, if it is perpetrator to perpetrator, we want to make sure that we're identifying other folks, and that preservation's a tough one too, to ask people to preserve their own evidence and put the sole responsibility only on the victim and user. So your points are right. Don't mistake me. They're great ideas, and want to hear more of those. So I've been very excited to hear the interventions here. So keep them coming. But yeah, with Salt Typhoon, we are very concerned. That's one of the reasons we're very huge proponents of making use of encryption. But I think it is worth noting that was actually not the attack vector. Again, it may be neither here nor there for you because the lawful intercept information was accessed. And again, we are all about protecting that in a better way ourselves as well.
Thank you, Katie. Andrew?
Yeah, two very quick, and they'll be a bit superficial for time, so we can maybe speak afterwards. On the indicators of compromise, two quick thoughts. One is, yes, encrypted DNS is useful to protect from a third-party observer, but you are sharing your data still with the resolver operator. Some of those resolver operators are maybe in operating under regimes where there's not a very good privacy regulation. So assuming that just by putting in encrypted DNS, you've fixed privacy, which isn't what you said, to be fair, but some people might just assume you do that, you're done. That's not true. You've got to consider who's operating the resolver as well. Otherwise, you may have bigger issues. And then also on the indicators of compromise, the issue is with things like ECH, you encrypt the SNI data, and that's absolutely used by firewalls and other software to identify when you have when an exploit has happened and when maybe data's being exfiltrated. So I think we need to be very careful, and some of the people that are working on that were maybe a bit focused on encryption and not so much on the broader security ecosystem, if you will. But that's probably a longer conversation that we can usefully have in the next 7 minutes, 21 seconds.
Is it Lloyd, or Honey, did you want to add anything on? Okay, we can move on. I'm now torn. Sir, please do ask the question. Boris, I will come to you next. We have only 7 minutes left, so we probably will run out of time for further questions, but please.
I'll try to be brief. Vittorio Bertola, I think I know most of the people in this conversation. And I mean, how many times have we been having this conversation at IGF, at the ITF in the last 10 years? I think like 20, 30. So and every time there's someone that comes and says, I mean, rightfully, I mean, if you do this, it will be abused. It will, I mean, whatever system you put to intercept, to give some lawful interception possibilities, may be abused or will be abused. And this is not the point. Unfortunately, there is a part of our society, in politics, in civil society, in public institutions, that thinks that even if it will be abused, it's still better than not having lawful interception. So the problem of this discussion is that it is really a political discussion of balances, of compromise. And I think that the compromise might be very different depending on which country you're from, when you live. There's how big is crime in your country, whether you have organized crime or you don't. So, I mean, allowing lawful interception in Norway is going to be very different than allowing it in Iran. So this is why, I mean, I'm starting to think that maybe we could focus this, I mean, the development of this in another direction, which is maybe, okay, every country will decide this at the political level, but if you decide to do this, can we find ways to prevent the bad effects from spilling over to other countries that decide they don't want to do this? And what's the best way of deciding this and of managing this? Do we have any advice for governments that in parliaments that still decide that they want to do this in terms of safeguards, in terms of technical ways of doing this? So maybe this could be a work strand that could be more productive than just restating the arguments every time. Thank you.
I admired the question as well, but I guess if it was an easy thing, then we wouldn't be recycling there. It would have been fixed. So I think that recognises the point, Andrew.
Yeah, great point, Vittorio. Can I just maybe build on that slightly without addressing it because it's a complex solution. I think if I extrapolate that a little, I think it's worth stating that, in my opinion, the status quo is just not acceptable. And the reason for that, and maybe a stat we probably ought to just remind ourselves because it's really important. If we look at child sexual abuse material, tech-facilitated child sexual abuse and exploitation, the current estimates are that there are roughly 300 million child victims annually. That's roughly 14% of the children across the world, which means every country, probably every one of us, we might not know them, but probably we've got sort of people close to us that are victims. So it's the sheer scale of the problem that unfortunately has been enabled by the internet, which is why I feel that we need to find a solution, but to Vittoria's point, accepting that there are trade-offs. We have to do this with accepting there are trade-offs and maybe try and minimise the risks of those trade-offs, but they will exist.
Thank you, Andrew. Lloyd, Katie, any response to that?
I think it was a really good point, actually, and I think that if we continue down this road, you're going to see a sort of split as nation states declare their sovereignty on the internet. It won't be that one unified thing anymore. You're going to see, well, if you're not going to come to this sort of standard because this is a country of law and order, then you're going to start seeing fracturing happen, I think. So I think it's a really good point that you can't compare. It's not a fair comparison to say what's going to happen in this country will happen in this country. We absolutely need these protections in place. We can't just stick our head in the sand and say, well, nothing we can do about it. We absolutely need to do something. And I think the risk here is the fracturing that we're going to see after the fact if we don't address this issue to some satisfactory sort of level.
Okay. So in the last couple of minutes, Boris, if we can, I'm now intrigued with all the conversation that apparently has been going on online. If you can summarise that in less than 2.5 minutes, that would be much appreciated.
That's not going to be possible. I just want to say thank you so much to everybody online as well for contributing. It's really difficult to follow some of these discussions because there's points going left and right, and please read them afterwards. I hope there's going to be recording. An interesting point has been raised, and I think that just showcases the point of this discussion in setting up a future discussion to have more diversity in our future panel discussions. And I think it's an important point to make, and many of the contributors online, I feel as well, would be great. One of the questions that was, I don't know if it was missed, what's the perspective of the panelists on the civic space impact of weaker privacy standards? There are good reasons, that the comments on kind of privacy reasons to use one sort of applications or other. Then there was a comment as well, high privacy technical standards are not kind of banning police investigations in more traditional ways and other technical investigative techniques. There was a diverse discussion online, and I just want to say one more thank you to everybody who contributed, and please keep on sending them. Thank you.
Okay, well, in the final 1 minute, I think it would just fall to me to pull this to a close. And Boris, I will start with a thank you to you to trying to summarise all of that. I think we've heard clearly a lot of the course of the last hour and a quarter, and there were some notable quotes. Katie, I think, is actually one of your first comments, which was encryption and safety have to coexist. We have to find solutions to this, despite, as the question said, it is, we keep coming around to this subject. It is clearly quite a difficult and complex issue, but one that we, Lloyd, as you just kind of reminded us, one that we have to resolve in some manner. And I really like the suggestion actually to focus in one particular place, and that's where we perhaps will start. I thank all of you for joining us this morning, as Andrew said, on the last and final day of the IGF. But if I can just close, if you can show your appreciation to what is an extraordinary panel. Thank you all so very much. Thank you.